and the officer made contact with the defendant asleep in the living room. The defendant woke up in
Whoa. No means no. Doesn't mean it's the holidays. Doesn't mean I have a birthday. A court order is a court.
This one is wild right from the jump. A cop literally walks into a man's house while he's asleep. No warrant, no knock, no announcement. Just straight up strolls into someone's living room like it's a public lobby. You can almost hear the Fourth Amendment screaming in the background. The guy wakes up to a police officer standing over him, confused, disoriented, and probably wondering if he's still dreaming. That alone should make anyone uncomfortable. And what makes it even worse is the officer's attitude. He's acting annoyed, like he's the one being inconvenienced here, as if breaking into someone's home is just part of the daily routine. No urgency, no clear emergency, no explanation that justifies crossing that line. This isn't a split-second decision in a life or death situation. This feels casual, careless, and completely detached from the basic rules that are supposed to protect people in their own homes. Cases like this really make you question what probable cause even means anymore. Is it evidence? Or is it just a gut feeling and a badge? Because last time I checked, I felt like it isn't a legal standard. The home is supposed to be the one place where privacy is absolute, and yet here we are watching it get ignored like it's optional, and so the real question is this. Do you think this officer will face any real consequences for this? Or is it going to get brushed off, justified, and quietly swept under the rug like we've seen so many times before? Let me know what you guys think, because this one raises some serious questions. Let's dive in and watch how this unfolds.
Good morning, Mr. Villagas. Good morning. Sir, you're charged with failure to give information upon striking a highway fixture. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Okay.
Yes, Judge. On December 28, 2024, the officer was dispatched to apartments in Harris County, Texas, in regard to a single vehicle accident that hit the mailbox of a residence. The officer observed the defendant's motor vehicle with heavy front end damage, but did not locate any driver or occupants inside the vehicle. During an inventory, the officer located the defendant's photo ID and Texas utility bill that came back to the defendant's name and address, approximately 1.4 miles from the accident. The registered owner of the mailbox came back to the defendant of the utility bill and his address. The officer went to the defendant's residence, noticed the garage door open and garage interior to the residence wide open. The officer made contact at the residence, one to make sure the motor vehicle was not stolen and one to make sure the owner of the vehicle was okay. The officer went inside the residence after knocking and announcing his presence several times under the community caretaking doctrine, and the officer made contact with the defendant asleep in the living room. The defendant woke up in
Whoa.
Yes, Judge. It was because they had...
Whoa.
Yes, the vehicle was damaged and he wanted to make sure the driver was okay. So he announced himself and went into the residence because the door was wide open.
Wow.
And then it was after that he saw the defendant asleep in the living room, and the defendant woke up and immediately said the car accident, that he did not cause any injuries or any trouble, and that he was driving his motor vehicle 2 to 3 hours prior, and that he was on his way to drop it off at a mechanic when his vehicle was hit. The defendant called the insurance company, and the defendant walked home because no one arrived on scene, and the defendant was going to pick up his motor vehicle in the morning. And the officer made contact with the complainant, who stated she heard a loud bang and observed damages, approximately $1,025.
So, are you telling me that he did stay though?
No. What happened, Your Honor, is that he struck the mailbox at the apartment, and the defendant said that he called his insurance. No one came to the scene, so he walked home. And the officer, when he arrived, saw the empty...
Did he make an attempt to make a phone call at the scene to anyone?
All he said is that he called the insurance company. That's the only person that he had stated he called. And then after that, he walked home because no one arrived on scene. And then that's when the officer arrived and saw his empty vehicle damaged. And then he found a utility bill and the ID.
I have so many questions. Let's do this. I'm going to appoint you a lawyer, or you have a lawyer, right? Let's do this. I'm going to hold off on finding probable cause at the moment. Let me wait for your lawyer to get here. We'll revisit PC here momentarily. Just go ahead and take a seat for me if you don't mind in the jury box. Yeah? Let's wait for your lawyer to get here and then we'll go forward. Michael. Yeah, come on in.
Mr. Jill Villagas, Your Honor.
Did you look at PC?
I think Mrs. We're prepared for argument.
Okay. Morgan, are you ready?
Yes, Judge.
This
This
is-
is Biagas, correct?
Biagas, yeah. Go for it. Okay. Ball's in your court.
Your Honor, Mr. Biagas, when he climbed to the mailbox pole, he didn't stop. He got out of the car. There's no one to talk to. And so from there, he went to his residence, Your Honor. But, it's not a case where he didn't identify himself or anything. And then we don't know what the restitution amount's going to be for the mailbox.
My concern was that according to the statute, right, it says that you're supposed to, I don't even know.
Reasonable steps to locate and notify the owner or person in charge of the property of the collision.
What time, was this the middle of the night?
1:50 in the morning.
I don't think it'd be reasonable to knock on anyone's door. I don't think anyone would open.
I mean, reasonable steps, you know where the person lives, you hit their mailbox. It would be pretty easy to walk up and knock on the door.
Is that reasonable? I mean, if you go up to someone's door at 2 a.m. and you start knocking on the door, are you going to scare the...
Probably, Judge, but I would want to know if it were my mailbox and somebody ran their car into it.
Would you open the door and go out?
I would look through the peephole and I'd see,
I
and then I would
guess
see a
there
crashed car.
are other measures I guess you could take theoretically.
Do something.
Right.
I guess leave.
Right.
Maybe leave a note on the door.
Okay, all right. Mr. Biagas, come up. I mean, reasonable measures, right? And I guess that would... Have you run his license, see if he has a valid Texas driver license?
It's an out-of-state Florida license that appears valid in our system.
Okay. Mr. Biagas, I'm going to find that there's probable cause to go forward with your case. I'm ordering you not to drive any vehicle unless you have car insurance in your name. Do you understand? If I find that you're driving without a license and or liability insurance in your name, it's not going to go well for you. Do you understand?
So let me get this straight. The cop shows up to the scene, doesn't actually see anyone there, finds some paperwork in a car, runs an address, and then decides to go full detective at 2 o'clock in the morning. That's not policing. That's literally the opening scene of a low-budget horror movie. Yeah, he knocked, I guess, but nobody answered. And somehow, in his mind, that turned into permission to just let himself inside. At that hour, no response doesn't mean everything's fine, come on in. It means people are asleep. Or worse, that someone breaking in is about to get mistaken for a burglar. Any sane person would assume a home invasion, not a welfare check. And this is where the Fourth Amendment is absolutely screaming. The law isn't vague here. Without consent or a real, articulable emergency, a home is off limits. Period. Even probable cause doesn't give you a free pass to cross that threshold just because you're curious or feel like following a hunch. That line is supposed to be bright and unbreakable. What makes this even more concerning is that the officer genuinely believed he was doing the right thing. That tells you how blurred the boundaries of authority have become. Just imagine waking up half asleep, hearing boots on your floor, and realizing it's not a thief. It's a cop who decided to invite himself in. If that were me, I'd think I was getting robbed too. This isn't just about one bad decision. It's about how easily basic constitutional protections get brushed aside when someone with a badge thinks the rules don't apply to them.
Okay. You've got a lawyer. Listen to your lawyer. He'll take care of you. I will waive your appearance so you don't have to waste your time coming to court, but you have to stay in touch with Mr. Pham. He'll tell you when you have to come back to court. If he tells me he can't get a hold of you or you pick up a new case, I'm going to revoke your bond, put you in jail. No more PR bonds. You understand? Okay, guys. Any conditions you think?
I'm okay with your conditions, Judge, just no driving without
Yeah,
insurance.
just
Law
be
violation.
careful out there, okay?
He does have insurance. Can you rip the CW?
Yes.
And then we can settle it.
You did have insurance?
Yes.
Hopefully.
Yes, sir.
Yeah, wonderful. Great. Okay, all right, man. Take care. Have fun. Can you file that? Do you mind those conditions? All right, Vic, you ready? Wow, really? Nice.
First day as well.
Hi, Judge. Good morning. Permission approach?
Yes, ma'am. How's it going?
Hi, Judge. Happy New Year.
New Year?
I'm here, Ms. Shaniqua Smith, Judge.
Okay.
I'd like to start with an update on it. We have everything submitted with for the DWI PTI program. However, Ms. Smith attempted to get the interlock device on her vehicle, but she has an electric vehicle, so she was told that it would not be able to get placed on her car. So Attorney Carter has been communicating with Beadle to try to figure out what we need to do then.
He's no longer here, so
We haven't heard back from him, so that's why.
yeah, he's not with the office anymore.
Okay. Okay.
Alex, do you have any idea what they do with electric vehicles?
So we do have information that she was approved for the DWI program. And then they emailed a procedure to follow. So presumably if she still follows the procedure outlined in the email sent from Beadle prior to his departure, then.
Well, the issue isn't necessarily the procedure, it's what do we do when we can't get the interlock device installed on the vehicle, which is part of the procedure based on her having an electric
Does she
car.
have another vehicle?
No, Judge. And I know she has to drive, so she can't do the portable because then she has to sign the affidavit, which would say she's sworn to not be able to drive.
So in that case, it would probably be best to reach out to Brenda Gomez or Bernadette Habe, who's in charge of right now the DWIs.
Hold on a second. Let's do that. And then, your client has bond violations too. Do you know that?
No, Judge, that I did not know.
Shanika Smith, come up. I'm printing this out for you.
Judge.
Who was the other one? Gomez, and who was the other one? Alex?
Bernadette Habe. I can.
Oh, she's Miss Habe. She's the one in charge of everything, right?
Yeah, she's the one overseeing.
I mean, if you want to go talk to her, but she's got bond violations. Yeah, you guys go figure out, but you've got bond violations, man. I don't know what we're going to do now. Okay, please.
Thank you, I'll step aside, thank you. Have permission to approach?
Yep.
Would you like me to ask Ms. Smith to come up again? Ms. Smith? And I spoke to Wolf and I didn't realize he had already had a conversation with her, Judge. And I will. I did speak to Wolven Carter and he advised that he had spoken to Ms. Smith as well regarding the possibility of this being the result. He and I spoke to her again just a moment ago. We were out there on call, and at this time, Judge, Ms. Smith, that we were going to have her speak on her own behalf, Judge. So I think it's important for her to take ownership for what this report showed.
I don't care. I'm putting an ankle monitor on you now. If you ever test positive for alcohol again, I'm going to put you in jail. That's it. No means no. Doesn't mean it's the holidays. Doesn't mean I have a birthday. A court order is a court order. And when you don't follow court orders, there's only one place that we have you go. There's no tolerance anymore. And I don't care what you come up here and say, whether it's mouthwash, a tequila lollipop, hair dye, I don't care. And I don't care who you're with. A second violation. Do you understand? Today you will get an ankle monitor, and I'm going to tell you now, it is extremely finicky. So best beware of anything that you put in your body. Okay, no more. That's it. Okay. As far as the other, I don't know. What I would suggest is, email if you can now, Brenda Gomez, and see how we handle it, because I don't know. All I know is that this case is nearly 200 days old, and now we have violations, and I'm ready to put this thing to bed. I'm not going to hold it anymore.
Yes,
So,
Judge, understood.
I'll give you guys to the end of the week, figure out what we need to do.
Okay.
But you're walking a very, very thin line. Do you understand? All right. So, Felicia, if we can amend it to put it on today, please. Yes, ma'am. Okay.
Thank you.
This second case honestly had me shaking my head the entire time. Judge Fleer was not in the mood, and you could tell right away. The moment she said, "I don't care," that was it. Game over. Next thing you know, she's getting fitted with an ankle monitor, like it's some accessory she never asked for. And the look on her face said everything. She's clearly exhausted from being told what to do, and Judge Fleer is beyond exhausted from hearing the same tired excuses. The second alcohol came up. You already knew this wasn't her first rodeo. That's what I respect about Judge Fleer, though he doesn't sugarcoat it. He doesn't give long speeches or try to sound dramatic. He just lays it out plain and simple. These are the rules, and if you break them, there are consequences. No back and forth, no emotional appeals, no nonsense. He runs his courtroom like someone who's seen every trick in the book. Because let's be honest, a lot of people don't realize how strict probation conditions really are. One harmless sip can absolutely violate court terms and land you in a cell for the night. It sounds harsh, but that's literally what accountability looks like in the system. Probation isn't about comfort. It's about proving you can follow basic rules without supervision breathing down your neck. And it really makes you wonder, do some people actually need consequences to finally grow up, or are they just addicted to chaos at this point? Because for some folks, it feels like they'd rather keep testing the system than just do the one thing asked of them. Let me know what you guys think about Judge Fleer. Some people say he's too soft. Some people respect his style. Personally, I enjoy how direct he is. But yeah, thank you so much for watching, guys. Make sure to like and subscribe, and take care.